Getting ready for your examination for discovery. What you need to know about discovery? Do's and do nots. You must watch this video in its entirety prior to your discovery prep meeting with one of our associate lawyers.
My name is Muhammad Alam and I am a senior lawyer and owner of the law firm of Alam Law, your lawyer in your injury matter. Today, I need your attention and I need to give you some background information so you are well prepped for your upcoming discovery. Now, you have to be watching and listening carefully the contents of this video before you attend the discovery prep meeting or the discovery. Your examination for discovery has been set, and I'm sure you must have received a letter from our office advising you on which date your examination for discovery has been scheduled. Now, for you, you may have several questions. What this discovery means, and from today's video, you will have a good idea what is going to happen at discovery, why discovery is important, how you should behave at discovery, what you should do and you should not do. So let's start with the purpose of the discovery. So in your personal injury litigation, either it's related to car accident, slip and fall, or long-term disability discovery. First of all, this discovery is an opportunity for you to explain to the other lawyer or defense lawyer how the accident happened, what injuries you have suffered, and how these injuries are affecting your activities of daily living or your work or your education, and which is critical for your case. Now, what this discovery is, it is really a back and forth question that a defense lawyer will be asking you, and you will be responding to those answers. So do not panic, first of all, because defense lawyer is not going to ask you any question about science or math. These questions will be about your life, about your injuries, about how the incident happened. So you don't have to worry about it, but the tips that I'm going to give it to you, the information that I am going to give it to you in this video is important to keep in mind while you're attending discovery. Well, we will also do the same question and answer session with the other driver who caused the accident, or the property owner in case of slip and fall accident, or to the insurance representative in case of a long-term disability or insurance coverage denial. But your discovery really means the other lawyer will be asking those questions, so you have to be very calm. Most importantly, in this discovery, the defense lawyer, through this cross-examination or through asking these questions, is really gauging you how good or bad witness you will be at trial if this matter proceed. And if the defense lawyer gauge you as a good witness, a credible person, which really means that they now learn that you are a witness who can convince a judge and jury, or a judge and jury can trust you and can give you an award. And if this is how your impression will be on the defense counsel, in my experience and opinion, those cases settle early. They may settle right after the discovery. They may want to go for a mediation, which is kind of a formal setting for a settlement discussion. And your case will be settled there. And majority of the cases settle, at mediation. Some cases do not settle for a variety of reasons. Either they don't have enough information, or they did not like you as a witness, or you are a bad witness, or you are not a credible witness. So you have to be patient, be nice with the defense counsel. On the other hand, I also wants to warn you, this discovery will be conducted by other party's lawyer. While majority of the defense counsel, they are nice, but there are many defense counsel who could be aggressive in their tone, but they will be still have to be respectful. But if they are nice, you should not conclude and volunteer information just because they are nice and you feel that this is a nice defense counsel and he was too polite, because you have to remember that lawyer works for other party. So he does not have the same interest as yours. So be careful and don't get into a trap of a defense lawyer who seems to be very nice. Moving forward from this introductory topic of examination for discovery, let's talk about injuries and threshold. So if you are attending a discovery for your car accident, you have to remember in the province of Ontario, there is a $40,000 deductible for your pain and suffer claim. And in addition to that, there is a threshold, which essentially means that in order to get compensation, you have to pass a threshold, which is called a serious and permanent injury, or serious and permanent injury of an important function of your body, either physical or psychological. Now, in a simple word, which essentially means that your injuries should have a serious and permanent impact on your functionability. And if it does not, then the court or the judge who is making a decision about a damage award, you may not be able to recover anything if you do not pass that threshold. Now, what this threshold really means, this is kind of a little bit legal understanding about how this threshold is decided. But for your purposes, as I said, your injury should be serious and it should be permanent, which means like it is not going to be resolved very soon, or there is a date that your injuries will be resolved. Now, as I said, this discovery is your opportunity to explain how the accident happened, what injuries you have suffered, and how these injuries have affected your life, either your activities of daily living or your work, kind of things that you used to enjoy and you are unable to enjoy now, or your education. Now, in car accident, more specifically, this portion that I'm talking about is very specific to the car accident victims, because there is a threshold applicable on a car accident claim for serious and permanent. From your evidence, it has to be clear that you have impairment on your function, not that you have pain. So let's take an example. If you only testify and give evidence at discovery that you have pain and you're taking medication and you are treating yourself by seeing family doctor, well, that is not enough in order to pass that hurdle that was brought by the legislation for car accident. You have to focus and find functions that you are unable to do as a result of your injuries. So let's take an example. A function of playing basketball or football or some sports activities, and now as a result of your injuries or pain, you are unable to do that function. That is one example. There could be many, many examples. That you have to delay your schooling, you are unable to carry out function at your work, which you used to do before the accident and before you suffered injuries. Let's take an example, that you are unable to drive, let's say long haul trucks because of your ankle fracture. So you have to focus on some of functions which are important and that you are unable to do or perform those functions as a result of your injuries. So I hope I was able to convey a message that at your discovery, that not only that you have to talk about pain, but you have to find out some of those functions that you used to do before the accident, which were important to your life or to your family, and you are unable to carry out those functions. And if you need more clarification, one of the lawyer will be preparing you for discovery. You can talk a little bit more about functional ability aspect of my discussion. Now, moving forward, if your discovery or your case is related to slip and fall accident, there is no threshold. There is no deductible apply in a slip and fall accident. Similarly, for long-term or short-term litigation, long-term and short-term insurance denial claim, there is no test for threshold for serious and permanent. There is no test applied for a $40,000 deductible for your pain and suffer. So going back to car accident now, one more time. As I said, like there's a $40,000 deductible for pain and suffer, and that's law in the province of Ontario. So whether or not you agree, or I don't agree, my clients do not agree, a victim who involved in a car accident, they, for example, do not agree that this is wrong, but that's the law today. Until or unless a judge and jury comes back for a pain and suffer damage award over $140,000, any award less than that will be subject to a $40,000 deductible, which means if the jury give you a $90,000 pain and suffer award, you will be walk out of the court with a $50,000 damage award. So 40 is gone. Now, moving forward from injury for threshold and deductible, which applies for car accident and which does not apply for slip and fall or other litigation. About your attendance this on the discovery. So before COVID, discoveries were happening in a court reporting center. You will be notified the location of the reporting center where the other party, which other driver or at fault property owner or insurance company who we have sued for your claim, they or their representative will be there, and we will examine them in that room. So while we are examining them, you will be sitting outside, and the defendant lawyer will be there. Your lawyer, myself or one of our lawyer, will be there for you to examine them, and there will be a court reporter who will be recording every single question, every single word that is being asked, and every single words that you have said in response to the question that is being asked. And that is your evidence. That evidence will be used in court if your case does not settle and it goes to trial. So you have to be very careful when what you say. Also, always remember this. Let's say in an injury case, we have all your medical records. Not only after your accident, what injuries you have suffered, what medication you have taken, which doctor you have seen, but your 2 to 3 years, and in certain cases even 5 years, medical record are relevant to obtain, and reviewed and share with the other lawyer, because they also wants to see if you're complaining that you have back pain. They are entitled to at least go back and see for 3 years whether or not you were suffering from back pain before the accident. So that is the reason that your pre-accident records are also shared with the other party, and they are entitled to review. So always remember, if you were complaining back pain before the accident for any reason, maybe because of another car accident, another slip and fall injury, for any other reason, maybe just naturally that you developed a back pain and you have seen a doctor, a specialist, have undergone for x-ray or took some medication, it is important that you should never deny having that problem before the accident, because if you do that, that will significantly compromise your credibility. And this is what defense lawyer want. They want that you to destroy your credibility, because they have record. And at trial, if your case does not settle, this will be a key evidence to put in front of a judge or jury, and the other lawyer will ask question. The other lawyer will put records, your pre-existing record, before judge and jury, who all can see that you had back pain before the accident, you were seeing a specialist, you took some medication. And at the examination for discovery, when a question was being asked, that if you had ever suffered a back injury or back problem, and you said no, and right there your credibility is compromised. So you never want to do that, because if your credibility is compromised at discovery, there are less chances that insurance company or other party would be interested to settle your case quicker, right after discovery or at mediation. And it's not about only one issue. There could be many other things that they can ask. Keep in mind, whatever you talk to your doctor, whatever complaint you made, all those records are available either in your clinical notes and records of your family doctor, or a decoded OHIP summary, which we obtained to look at your health condition before the accident and compare it with the after the accident injuries. So we have those information. And remember this: the other lawyer, he also have that information readily available to you. He will keep a blind eye if you say that you never had this problem. If you have question, let's take an example that you had a previous accident which you have not disclosed to us, or if you have a previous slip and fall at home which you have not disclosed, better you disclose to your lawyer who is giving you preparation for discovery. So at least we can address that issue with you before you go for examination for discovery and testify. Now, a few more things in terms of examination for discovery. As I said, the court reporter is there. Court reporter is recording every single thing that you are saying. You must ensure that you turn off your cell phone at the discovery when you're attending. Do not carry, piece of paper or other documents with you while you are giving discovery evidence. In addition, don't make any notes while you're giving answers. This same equally applies to today's world, when most of the discoveries are being conducted via Zoom. And I'll talk to you in a second about Zoom, what you should do. But same thing applies to Zoom, that even if you are at your home, when you're giving evidence, look at the camera and provide your answer. Make sure that you have a dedicated room. Other people are not around you. You're not recording the proceeding because that will be against law. You're not taking a screenshot of the proceeding. Plus, if you're attending from home, you also have to make sure that you have a good, stable internet connection and a dedicated laptop or computer or a tablet, so you can have a smooth discovery. If you have doubt about your technical abilities, you are elderly, or for any reason you feel not comfortable handling this technology, then better you let our office know that you would like to attend discovery from our office. Because if there are problems on internet and discovery is being canceled, then the other lawyer may seek cost for his attendance. We have to pay court reporting center for the day, which you don't want, and then your discovery will have to be rescheduled on another date, and it will go probably next 6 or 8 months. We will get the new date. So again, If you are not confident, if you have, about internet connection or stability of internet connection, better you attend the discovery from our office, where you will be provided all these technology or technological support, and the staff will be there to help you if there is any problem. In addition, there is another thing that I want to add. That examination for discovery, there are certain questions are being asked, and you may be thinking that question, that you should not be giving the answer to that question. Well, that is not true, because examination for discovery, your lawyer is sitting beside you. So even a physical discovery or even virtual discovery, your lawyer is present. As an ordinary person, you may think certain questions are, you are not supposed to answer, and you're telling defense counsel that you are not going to give the answer. Don't do that. Until or unless your lawyer from Alam Law sitting beside you object to a question, rest of the question you need to answer. And again, in terms of answering question, you are entitled to ask defense counsel if you are not sure, or if you did not understand the question. You can ask even 1 time, 2 times, or even 3 times to the counsel and ask them to repeat the question or rephrase the question as you were unable to understand what you were asking, which is perfectly all right. If you need, let's say, a break, feel free to ask defense counsel that you need 5-minute break. You will be given proper break if it's full day discovery for lunch, but during the discovery, at any moment you feel overwhelmed, you need a few minutes break for tea or coffee, feel free to ask your lawyer, and we will arrange that break for you. Now, a few other things which is also connected about credibility. At discovery, so more so at in-person discovery than Zoom, defense counsel is also watching your posture, watching how you sit. He's also watching many other things. So let's take an example. At the discovery, when you say to defense counsel that because of your back pain you are unable to work, or you have limitation that you cannot sit more than 20 minutes or 30 minutes, and at the discovery you are sitting for 2 hours, that's contradict what you just said to defense counsel, number one. So I mean, if you need break and you're sitting with pain, you have all the right to take a 5-minute break and stretch yourself, and then come back and restart your discovery. But one thing for sure, I would stress you that do not overdo this, because that will also compromise your credibility. I have just be genuine, real in your expression, in how you talk, how you sit. I have seen, I just want to share an example of one of our client, obviously without disclosing name, which I felt very embarrassed, and client has some back issues and also has some shoulder injury, nothing significant or shoulder fracture, but she has some shoulder condition. And at the discovery, she wants to drink water. There was a glass of water, and she was holding the glass with the support of the other hand to drink the water. I also genuinely believe that was not necessary, because I have seen many times in my office, drinking tea and coffee and bottle of water. So that support was not needed to hold the glass. Maybe she thought she can impress the defense counsel that you require, a support of the hand because you cannot lift your hand. But I can tell you that always gave a very wrong message. I mean, until you have really a significant fracture and doctor wants that you do not move your hand above certain level, This gave a very bad impression. There's another client that I have seen, at discovery. He was twisted and turning and showing frustration about his back pain. And every so often in 5 minutes he will stand up and show some sort of pain. He may be thinking that he is impressing the defense counsel, but I can tell you this: defense counsel will never get impressed. In fact, he will be smiling in his heart, and he will write this report, specifically these kind of incident, to their client, and writing their client that this person is really not credible. He is not a likable witness. So keep those little tips in your mind when you're attending examination for discovery. So before I forget anything, let me see. So about timings, very important. If your discovery is at 10 o'clock, I'm sure my office will tell you that you should be there a little early, just in case if you need some information or clear out in terms of dress. So you don't have to be dressing up or dressing suit or tie or something fancy. Just be comfortable, as everyday dress that you wear. If you have question, the person who sent you the discovery prep email, or the person at the office who sent you the discovery letter, feel free to reach out to them by email. That is always preferred and faster. Another thing before your discovery start, the court reporter will ask you that whether or not you want to give your testimony by taking oath or affirm. Some people religiously believe that they can take oath on the holy book, but at the same time you can avoid, if you don't want to take oath, you can tell or advise the court reporter that you want to affirm, and the court reporter will affirm, which essentially means that that you affirm to tell the truth and nothing but the truth. So that is your choice. And also, as earlier I said, that this is your only opportunity to impress the other party's lawyer that you are credible, and you are able to explain that how your injuries are affecting you. What medication you are taking, which doctors you have seen, which treatment you have been taking. Are you attending physio? How many times? Or psychotherapy treatment, or you're seeing some specialist, and seeing your family doctor regularly. Those informations, and how your medication relieve you temporarily, if that is the case, and then your pain comes back, and then you have to take medication again. If that is the case, you can probably explain to defense counsel. In terms of a structure, like how does discovery proceed, the defense counsel, you will see that he or she will not be rushing you, but you have to be patient and listen the question very carefully. Sometime what happened, like the defense counsel is asking question, he is halfway through and you already know the answer, and before he finishes question, you jump in and you answer the question. Don't do that, because the evidence is being recorded. It will be overlap each other. So let defense counsel finish his question, understand the question, and then respond accordingly. A few more tips in terms of responding. First of all, you have to keep in mind that do not volunteer information. So only answer or provide information for the question that is being asked. So let me give you a very simple example. So if the other lawyer asks you, what was the color of the other vehicle? And if you know red, your answer should be red. And if you are not sure, your answer should be I'm not sure, or I do not recall. don't try to start talking more than necessary and more than what is being asked. If you start talking that, yeah, it was Ford, I believe, a very old vehicle, it was a small vehicle, it was red color. Well, this was not the question. The question was, what was the color? And then all you have to answer the color. So that's also you have to keep in mind. Do not give explanation or try to convince the defense counsel that your injuries are serious and you are suffering and your life has significantly affected. You don't have to convince him. And that's a major mistake that many of injured people who go for discovery, and if they're not properly prepped, they make that mistake and they think that this is an opportunity to convince the other lawyer that you're suffering. No, you don't have to convince. All you have to answer the question. All you have to understand that this is your opportunity to, when you're giving the answer, if a further explanation is needed in terms of how your life is affected, and if defense counsel does not ask or explore that area, and if you get a little chance to explain, then you can explain. But your general theme is just be restricted to the question, whatever question he asks or she asks, you just give an answer to that. You don't have to convince to the other lawyer, because records speak itself, and they have those records. In addition, there's another thing that many of our clients have done in the past and made that mistake. The use of word never, which essentially means if defense counsel asks you that, yeah, you were injured, you have fracture in your ankle, you were unable to, do your housekeeping task or lawn maintenance or snow removal or grocery shopping, because many of your record in the past, you may have told a doctor when you had serious injuries that you are not cutting grass, or you do not do grocery shopping or heavy shopping. But that may not be true now, and there could be some incident while you even hired a help for snow cleaning or grass cutting. There are times that you may have used snow shovel, or you may have done snow shoveling or done grass cutting. So never say never, that I have never snow cleaned on my driveway in the last 4 years. And why this is important, because if the defense counsel or other party has a surveillance on you, and they found you on a surveillance that you were cleaning snow or cutting grass, even on that one moment, your credibility will be significantly shattered by this evidence. So if you remember that, in last season you have done once or twice, just because nobody was available, and with your pain, and despite you had a lot of pain and you were unable to do a proper job, you still tried. That is a better evidence that you tried and you did once or twice, if you recall that you have done once or twice. The most important thing that I want to bring to your attention: not every claim the insurance company or defense counsel will do surveillance. There are certain insurance companies against who your claim is being advanced. They do surveillance, others don't. Certain cases are being picked by insurance companies to conduct a surveillance on you, and they are entitled to do it, because you are in a lawsuit. And in majority of the cases, I have seen that insurance company or defense lawyer will pick a specific file for surveillance where an injured person has soft tissues injuries, but to every doctor, he's saying that I cannot go back to work, I'm unable to work, I'm unable to do my housekeeping, I do nothing at home at all. Whereas the medical doctors are not, or their reports are not suggesting that you are unable to work. And in those cases, insurance companies and their lawyers get very suspicious about legitimacy of your claim, that with minor neck pain, how can you not work a sedentary job? While there are situations, for example, if you have emotional psychological issues and depression, in those circumstances, you may not be able to work and your doctor is supporting. So you have to be mindful of that. You also have to be mindful another important aspect in today's world, which is called social media. We always remind a client that you have to be careful what you post on social media. Insurance companies and defense lawyers are religiously now these days, every claim that they get or every discovery they coming to their desk, they go to social media and try to find that person and see their activities. And that activities can significantly compromise your evidence at discovery. I have a client who testified that he is not going outside for the last 1 year. He's isolated. He is not meeting friends. But in a social media post, that person has several postings within the last 1 year, where he's attending Niagara Fall, he's attending parties. That is significantly compromise his credibility. So please avoid posting posts or making such posts on social media, which can compromise your credibility, or which can be very different than what you have been telling me, or which you will tell to defense counsel. So be very mindful, be responsible, and aware that your social media, which is access to the public, and those posts can be seen by a defense lawyer. They may ask you a question about social media, whether or not you have a Facebook account or Twitter account. And if you have an account, you have to say yes. You can't say no. If you have an account, then they may ask your lawyer to preserve that account, because they want to see that account, what kind of posting you have done. There's one client, I give example always, he had, although he had significant problem, physical injuries, but at one venture he went to a building, and where he was doing some sports activities, which is very, very physically demanding, and diving from that building, which really shattered his credibility. And I genuinely believe that person was suffering, but on that day, I don't know how he did, but at the end of the day, judge and jury, if whoever is making decision of your case, it goes to trial, they will look at the video and they will unnecessarily doubt your other evidence, which you have given at the examination for discovery. Now, a few more tips. Any answer or any question for which you do not know the answer, do not guess. If you do not know the answer, you just simply say, you do not know the answer, or you do not know. If you do not know the answer, but you may have the answer at home somewhere written, you can tell defense counsel that I do not know, but I may be able to find that information and give it to my lawyer, and who can forward that information to you. Zoom, we talked about. Breaks, we talk about. The other thing, if you need an interpreter for your discovery, please make sure that you send an email to the person who sent you discovery letter, or the lawyer who is preparing you for discovery. Before your discovery prep, you either notify my staff that you require interpreter for your discovery, because many of our clients who are able to speak to our lawyers who do not speak their language, but their English is not great, which can be okay while we are preparing you, because but if you don't want to take chance, for example, examination for discovery, you're nervous that you will not be able to explain or express certain things, then notify us to arrange an interpreter. In addition, sometimes they ask question about you're attending physio treatments and this clinic that you're attending. How did you come across that clinic? Who referred you to this clinic? So if it's referred by a family doctor, you can tell your family doctor. If it's referred by a friend, you can tell about a friend, or if the clinic is in your neighborhood, or however you know that clinic. Sometimes people or some of our clients make mistakes and they tell that your lawyer has sent you to the clinic. I believe there's sometimes some misunderstanding happen with the client rather than because we are engaged with your clinic on a regular basis and we speak to them for your records and your medical condition. Clients sometimes get impression that we know the clinic, and you just rather than understanding the question, you just simply says that my lawyer knows the clinic. You have to be very careful when you answer this question. If you have any confusion or need clarification, you can always speak to the lawyer that you are speaking for your discovery prep. Surveillance we talk about, social media we talk about. The other thing, at the discovery, once your discovery has started, you cannot look at me or other lawyer that you need some information to answer this question. You cannot look at your lawyer who can give you or help you or provide an answer on your behalf. You are there, you have to answer. If you do not know the answer, you can say so. If you do not recall, you can just say you do not recall the information. But you cannot say, defense counsel, that I will not answer this question, because that is only on your lawyer. If your lawyer believes that question needs to be objected, your lawyer will do it. I believe it's about 34, 35 or maybe 40 minutes of discovery prep video that I would like to share with all of you, so you have some better knowledge. If you want to watch it again, please watch this video again, so you have certain tips and have better understanding about your discovery process. It will relieve you from some of the anxiety that you may have before you attend discovery. It gives you a great picture, certain do and don'ts. And I once again thank you for choosing Alam Law. I rest assured that we will work hard to the best of our ability to achieve the result, which is fair, and we will continue keep fighting if they do not settle your case earlier. Thank you.